The case we are about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. The prosecution in this case is represented by Michael Allen, Dave Young, and Angelina Gratiano. They are attorneys with the district attorney's office. I will sometimes refer to the district attorney as the prosecution or the people. In this case, the defendant or accused is Letecia Stauch, and she is being represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called an information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not in this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case? Great, thank you. Go ahead and have a seat. Before we go any further, do any of you have any difficulty either hearing or seeing what's going on in the courtroom? No response. In this case, 12 jurors and 6 alternates will be chosen. They will consider all the evidence produced during the trial. The jurors will determine what the facts are based on this evidence. The process that we have here that we've been going through for a number of days is that we're bringing in 75 people a day, and we will keep doing that until we qualify about 110. Then we will bring those 110 back in one group, and we will select the jury from that 110. The attorneys anticipate this case will take 6 weeks for trial. That does not include deliberations or jury selection. We hope to start the presentation of evidence on April 3 of 2023, so that would mean finishing evidence sometime in mid to late May. I understand the burden such a lengthy trial places on people. I previously presided over a case that went 18 weeks from start to finish. So I've been through this before. I understand how difficult this is and how long this is. Our trial days will generally be from 9 to 5, Monday, Tuesday, Wednesday, and Friday. There will be no trial on any Thursdays, as I have other docket matters that I have to attend to. You will be able to go home to your families each day, and though you will not be able to discuss anything about this case with them, you will be able to talk to them about anything else. You will also be able to continue to use the internet and view newspaper stories, all of those things, just not about this case. So you'll be able to go on about your life except for this case. You'll need to avoid everything with respect to that. Knowing this time commitment, is there anyone who believes they would suffer an undue or extreme hardship if required to serve for this trial? Please raise your hand, and I'm going to do this in sections. So starting over here first. All right, let's see, 1, 2, 4, 6. Juror number 6. Yes, ma'am. You said the court date is on May 1? Yes. And what is that for? How long is it going to be, do you know?
No. Might be that day, might have to be postponed again.
Okay.
It's my husband.
Okay.
He was back.
Okay. So it's not your court date, it's his. Okay. All right. And when are the major doctor appointments?
One's in April and one's in
Okay.
and cardiology.
And are they for you or for your husband?
Mine's 6 months out already,
I'm sorry?
6 months ago.
Okay. Anyone else in the back? Juror number 9? Did you say it was nursing school? Okay. Anyone else in the back? Juror number 5?
Trip plan to New York, April 25th through May 10th. Ticket.
Okay. Anyone else in the back? Oh, all right, front row, Juror 13? Yes, sir. Yes, sir.
For a company that's shutting down, part of a small group that is facilitating.
It's taken a while to shut down, I take it. Oh. Okay. All right. And Juror 14, did you have your hand up, sir? The gentleman, 14, okay, I misunderstood. Is there anybody else in the front row? Oh, Juror 15, yes, ma'am.
I have a trip that is paid for May 2nd through the 7th for my daughter qualified for nationals. For just documentation probably.
No, what'd she qualify in?
She is, she's a tumbler, level 5 tumbler. She qualified for cheer nationals in
Okay.
Florida.
All right. Anyone else in the front row? Juror 19?
I am going to be out of the country.
All right. Is there anyone else in this group that I've not spoken with? No. All right. This section over here, front row. Juror 24 there on the end. Yes, ma'am. Okay. Okay. Juror 25, did you have your hand up, ma'am? No, it was, was not. Okay, Juror 26, yes, ma'am. You're going to be having what? Okay. Okay. Juror 27, did you have your hand up? Yes, Juror 27? Where do you go to school? Cowboys. All right, and in the second row? No, okay, need you to, yep, there you go. All right, Juror 36, yes, sir. Yes, that's you. Juror, anyone else? Juror 37, yes, sir. All right. Anyone else in that second row? No. All right, third row and Juror 54. Yes, you, sir. Yeah. What kind of work do you do? You do what? Oh, Juror 55. Okay. Anyone else in that group that I missed? Juror 49. Okay. Others in that row, juror 65. Yes, ma'am. All right. What kind of work do you do? Yeah, when is your funeral?
Today at 10.
Thank you for your service. We'll let you go. Juror 67? Yes, sir. And juror 69 on the end?
Graduation.
Wouldn't be able to work nights, so tell me about the work issue.
I'm a custodian at Manitou High School. I work from one to
Well, what I'm trying to convey here is if you are selected to serve as a juror, you cannot work. And you won't be able to go to your work. Okay, that's what I'm trying to get to. Okay. So, so for you, it's a loss of income issue. Thank you. Last row. Juror 70 on the end over here. Yes, ma'am. Juror 74. Okay, so the wedding is here.
Yes.
And when is it? Well, that's a Saturday, so this won't interfere with your ability to attend on the Saturday.
No, but
All right, thank you. Is there anyone that I've not talked with that would have a undue or severe hardship if asked to serve as a juror in this case for 6 weeks? I can call on you said 32. Yes, sir.
You did, but I guess it'd be a loss of income after doing some of the other, it'd be a loss of income. I work nights with post office.
I want you to check with your employer over the noon hour. And the reason why I say that is, as I've said, this isn't my first long trial. And I've had employees from the post office before, and at least at that point in time, they were paid for their jury service for the entire time. So I want you to check because it's possible that that has changed. but at least at the last time that I did this, that was the case. Okay. Anyone, okay. Juror 35 on the end over here? Yes, sir.
Financial hardship. Trial that he- Last year, back to work.
What kind of work do you do? Here? Oh, all right, okay, oh. Ed, all right. I probably shouldn't ask that question of whether it was here. But yeah, okay, all right. And I thought I saw another hand. I've already spoken with juror 25. Juror 17.
Self-employed as well, and that would be no.
What kind of work do you do? Is there anyone else? Let's see. No, I see you there. I'm just trying to make sure I have the right numbers, so just hold on. Juror 59. That is you, yeah.
I just wanted to add that.
Juror number 1.
Well, I'm studying for MCAT, and if I don't study 2 hours every day, my exam's coming up in May.
When are your MCATs?
May.
What time? The beginning or end? I'm sorry?
I haven't picked the date yet.
Okay.
but
Anyone else? No? I've got everything. Got everything. Okay. All right. Let me make sure. Okay. All right. Let me also, at this time, I need to go through a list of questions which would disqualify you, and you should raise your hand if any of these apply to you. Are any of you related to the defendant or any of the attorneys? Anybody think they fit in that category? No response? Do any of you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of, or a partner in business with, or surety on any bond or obligation for the defendant? We're essentially looking for certain legal relationships with the defendant. Does anyone think they fit in that category? No response? Are you now or have you ever been a party in a civil lawsuit involving the defendant or have complained against or been accused by her in a criminal prosecution? Anyone think they're in that category? No response? Were any of you a witness to the matter related to the crime or its prosecution? Do any of you believe that you would be a witness in this case? No response? Do any of you have a personal or financial interest in the outcome of this case? No response. Are any of you a public law, easy for me to say. Are any of you an employee of any public law enforcement agency or the public defender's office? And juror number 3, yes, sir.
Deputy U.S. Marshal.
Okay. We're going to excuse you at this time. Thank you, sir. And you don't have to report back to the jury assembly room or anything like that. You can just go on about your business. Thank you. Anyone else? All right, let's have everybody turn off their cell phones if they would, please. Okay, all right. Do any of you have any feelings or a bias for or against the defendant or the prosecution in that category? Looks like we have a couple of hands. I'll go through those one at a time. Juror number 14, yes, sir.
As a father to young children, I have an emotional bias against the defendant.
Okay. Oh. Thought I saw another hand over. Okay, there we go. Juror 17.
Fine, to hear everybody from your neighbor.
Okay. I want you to hold on to that thought because we have a different question later about publicity and things that you may have heard regardless of source. And it sounds like that may be what you're talking about. Is that fair? Okay. Anyone else in this group? No. Anyone in this group back here? Let's see. Juror number 38. Yes, ma'am. Okay. I missed the first part. You have what? Children? Young children. Okay. Juror 39, did you have your hand? Yes, ma'am. Jury 39?
Not sure if this is where it fits. Yes, I worked as a children's. Child abuse.
Okay. No, I appreciate you bringing that up and this is the place to bring that up. So this is more of, you don't know anything specific about this case, but because this case involves a child victim, that's what you're thinking about. Is that fair?
Yes.
Okay. Anyone else in that second row? And in the last row, juror 49. Okay. And I don't want to make that worse, but I do need to inquire a little bit. Is it, being in here with everyone? Is it the facts of this case? Do you know something specific about this case? Okay. And anyone else in the back row? Front row over here. Juror 29. Yes, ma'am.
Very set my opinion on.
Said you're emotionally biased against what? And what is that based on? The publicity? Okay. And we'll get to that in just a moment. Okay. Juror 30, did you have your hand up, sir? Yes, sir. That's okay. There's no right or wrong answers here. Anyone else in the front row? Juror 32.
Same as, others, I have 4 small children that may affect.
And juror 33, I think now might be the time to talk about the concerns that you had raised earlier. Tell me about those.
I was arrested, in a public parking lot. My blood sugar was high and my diabetes was high. So they had an ambulance come out, they tested it, they said they're high, you can't drive. So they told me to walk off the premises. They didn't give me the address where the premises ended. So I started coming back and the police come back. Another ambulance comes back. Then they do the same thing, but this time they throw me on a gurney. Hospital. Next 3 days, I'm at psych. I had to pay $2,000 for this. There's nothing wrong with
Okay. And when did that occur?
it. About 3 years ago.
Okay.
But this is why I am extremely mad at the police department. No reason. I have to do this. To me.
Okay.
This is why I owe this county nothing.
Okay.
I had to pay it.
All right. Is there anyone else in the front row? No. Second row. And let's see. Juror 44. Yes, ma'am. We'll talk about that in just a little bit because I have some things to tell you about that. So keep that in your mind because we're going to come back to that. We're going to circle back around to that. Okay. Juror 35. Yes, sir. All right. And I'm sorry, that's actually juror 45, not 35. Anyone else in that second row? Third row? Let's start with juror number 60 over here. I'm sorry, 61. Yes, ma'am. No, 61 right there. Yep. In the beige. All right. And juror 62, or yes, juror 62. Okay, I want you to hold on to that thought because we're going to get into that a little bit later. This is a slightly different, but I want you to hold on to that thought, okay? And in the row behind, the third row back, no, I know that. Third row back, anyone in the third row? Or I'm sorry, fourth row, anyone in the fourth row? Okay. On the juror 69, okay. Anyone else in the fourth row? And, juror 74? Okay. All right, all right, thank you. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they fit in that category? Please raise your hand if you are unable to read, speak, or understand the English language. Anyone think they're in that category? Please raise your hand if you are incapable due to physical or mental limitations to render satisfactory jury service. I don't think they're in that category. Oh, hold on. Juror number 4. The mental ones, I'll do my best and it's not going to help you. No, I mean, it's not going to help you because the explanation isn't very good. The physical ones are fairly easy. We've had some gentlemen, or some people that have come through that have just had a surgical procedure and they have to be near a bathroom, and they have to be able to take frequent breaks, those kinds of things. So that's kind of what we're looking for. The mental ones are less frequent, largely because it has to deal with sometimes people are on medications as a result of surgery. So they're having to take a course of medication beforehand, or sometimes they're having to take a course of medication before they start a particular treatment. And that medication affects their ability to be able to follow through, understand, and those kinds of things. There's not a real good definition for it, so I'm not sure I'm real helpful on that. Is there something that you had in mind?
I suffer from
That's something that we want to know about. It's not quite in this category, but that is something that we do want to know about. So I'm glad that you brought it up and I'm glad that you're letting us know. Okay. Anyone else? Juror 49. No, but it's something that we need to know about because it's a little bit different. Okay. What we're talking about is something that really just prevents you from being able to do it entirely. So it's a little bit different. Juror 41. Yes, ma'am. Okay. Okay. Well, I'm glad you brought that up. I've had parties and people in the back who have had social or who have had seizure issues. So I'm glad that you let us know about that so that we know that potentially that might be out there. Is there anything specific that we can do to help you if that occurs? Okay. Okay. I have had parties and other people come into the courtroom with a service dog that helped them with seizures. Do you have a service animal? Okay. All right. I understand. I understand. It's every issue. I understand. Same thing. I understand. It's every issue. Um, so I understand. Um, Let's see, is there anyone aside from juror 24 and 59 that I missed? All right. Let's see, please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household such that your service would create a substantial risk of injury to the health of that disabled person. No response. Please raise your hand if you have served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Has anyone been on a jury in the last 12 months? No response? All right. Give me just a minute. All right, what we're gonna do is take about a 15-minute recess at this point. And, again, don't discuss the case with anyone else. Don't discuss the case among yourselves. When we come back, I will be excusing a number of you, and then we will go from there. So all rise for the jury, please. Oh, you can go ahead and leave. It's all right. Sorry. Oh, wait, before you go, and before everybody moves, make sure that you know where you're sitting. We honor the third grade seating chart here. Causes all kinds of consternation if you come back and sit in somebody else's seat. So with that, go ahead and step out in the hallway. Thank you.
Or by the microphone.
Yeah, there you go.
On January 19, 2023, Oakley May Carolyn Snow was last seen in Cromwell, Oklahoma. She left Oklahoma to go to Indianapolis, Indiana with her biological mother, Maddie Madison Marshall, her 8-month-old brother Colton, and a man named Roan Waters. It's alleged both are on drugs and that the man, Roan, has already abused Oakley previously. On Thursday, February 9th, Maddie stated to the father that she had dropped the child off anonymously at a hospital there in Indiana. And since that time, the father has not had any confirmation of the child's whereabouts, and the mom is not talking. Now, the brother was found abandoned and taken into CPS custody in Indiana. And as of yesterday, the father was on his way to get him. The dad claims on social media that the boy was injured in some capacity. The man that Maddie left with, Roan Waters, was charged with child abuse and domestic assault and battery in presence of a minor on November 7th, 2022, and was arrested while with Maddie in Colorado, presumably on their way to Indiana. Additionally, on March 16th, 2023, charges were filed against Maddie for 2 separate accounts of neglect of a dependent by the way of abandonment. One count was on February 1st, and the second was on February 9th. As of the filming of this video, the mother has spoken with people, but she has not been located. Oakley is approximately 2 foot tall and weighs 35 pounds. She has blonde hair and blue eyes. Anyone with information on Oakley's whereabouts is asked to contact Indianapolis Metropolitan Police Department at 317-327-6160 or dial 911 if you see either of them.
Had not only taken Garrett's life, but had desecrated the body. by leaving another disturbing message.
A seemingly innocent 16-year-old girl vanishes from home after recently meeting a young man 2 days prior. 2 calls home to mom, one asking to be picked up, another saying they won't let her go. All social media disabled. This is the story of missing Alinka Avila from Carson, California. Good evening, everybody. Welcome to Carrie Moody True Crime. This evening, I want to spread awareness on a case out of California with a 16-year-old missing girl. Now, NBC Los Angeles did a write-up on that, and I'd like to share that with you. This article was just published 3 days ago on March 14th, 2023, and it reads, a mother from Carson is living a nightmare after the disappearance of her 16-year-old daughter. Her daughter left home in January, but a few weeks later, she received a phone call that made her fear that her daughter is being kept against her will. 2 months have passed since the teen left home. Her mother says she didn't have many friends, she didn't go to parties, and was not one to date. Alinka Vila left her home in Carson on the morning of January 1st without any identification, without her credit card, and without a change of clothes. Since she left, her cell phone has remained disconnected and her social media accounts have also been disabled. Please help me find my daughter before it's too late, please, said Marciela Avila, her mother. Her mother says she didn't hang out with many friends, but she did meet a young man 2 days before her disappearance. We thought she had gone with someone, but we don't know, Marciela said. Soon after Alinka left, the family received a phone call, which was traced to the Venice area. She said, they have me and they won't let me go, Marciela said. Everything has changed since then for everyone. The family has posted thousands of signs with Alinka's picture, hoping someone has seen her or knows something. Every time I give a sign to a person, I ask God that this is the one who will help me find my daughter, Marciela said. I want her to know that I won't rest until I have her back here with me. Detectives from the Carson Sheriff's Department are investigating this case as an at-risk youth. My heart hurts, but I think they have her working as a prostitute, I think, Marciela said. The authorities can't confirm if the girl is being sex trafficked. For now, they're asking for any clues on her location. Alinka has called her family twice and once asked them to pick her up near Union Station, but she never showed up. When the family has tried to call the numbers back, they no longer exist. So anyone with any information on Alinka's whereabouts are asked to contact the sheriff department in Carson, California. Now, Alinka's mother is on Facebook and she's been very active since her daughter went missing on trying to get this information out. There is a slight language barrier. I believe the mother speaks Spanish only. She has done an interview, and I have a screenshot of that here. It was with Univision 34 Los Angeles. So if you'd like to listen to that interview, it is in Spanish only. But if you know Spanish, please go take a listen to it. Please share her story. It sounds like a scary situation since she has tried to contact her mother twice and they do not know where she is.
There's a lot of people up there. So Elton John once told me,
I've got all of them off on both, yeah. Right, so that, no, this is a good way to do it. So we should, hopefully that will resolve that issue. Right, right. Yeah. You know, and that's, yeah, it is. Yeah. Well, I think there are good uses for it, but it's one more thing that the judge has to keep track of. And when they were talking about, I think that bill is still in front of the legislature. I think there were, I don't know if it was courtrooms or courthouses, but there were about 100 of them in the state that had none, none at all. Right. So, um, right. Well, and the other thing that they don't think about was, the separation between state and county, because I had a problem in my courtroom a couple of weeks ago. Our technology was working fine, but the projector in the middle of from the ceiling is owned by the county and installed by the county. And so we could do everything that we could, but we don't have anything to do with that. And so we had to get both of them over here at the same time. And it just is, there are some logistical hurdles that I think are not being considered. But I have to say, you know, I have done it. I actually did a virtual trial where I was the only one in the courtroom for about 8 days. It was weird the first time I took the bench, but
The whole thing was virtual?
yeah, I was the only one in the courtroom. hmm it took a little getting used to, but it worked okay. Is it, the podium should be turned off as well. We turned off the podium and all those microphones at council table. Oh, yes. What will happen when you get there is you have various options. All those cords that are now draped over the back, you can connect to a laptop. There's also a Elmo in the side of the podium. And so and there's also a connection similar to what you have at the table on the podium. So you just need to let me know, because I have a preview screen up here. So when you get to that point, if you want to come in a little bit earlier or something like that and see how it works. Have you ever been in here and used it before? Okay. So if you want to try it out, just let us know and we can work that out. But it's really pretty easy. I can't count the number of times I've been in here and used it, so it works fine.
What I'm getting back is that they think.
Okay. We think we figured it out. Okay, let's go ahead and let the jurors back in. All rise for the jury, please. will recall 20 CR 135. I get all the way done. As a group, when you go, you do not need to go back to the jury room. So you're free to go about your business, continue on with whatever you want to do. So at this point in time, we're going to excuse juror number 1. Six. Right. All right. At this point in time, I'm going to give the attorneys an opportunity to give sort of a 2-minute, and it really is only 2 minutes, mini opening statement. It's just an opportunity for them to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you were selected to serve as jurors in this case. With that, prosecution.
January 27th, 2020. Dan Stauch by his stepmother. Brutally murdered by a series of choices and decisions accomplishing that. Chose first a knife, stabbed him 18 times. He fought for his life. He has cuts on his arms and his hands. Trying to chose to use a blunt force object, smash his head in, fracturing his skull. Then she chose to get a gun, a handgun. Fire that gun 3 times, striking him in his chin. Then she made the decision to clean up the crime scene. Then she made the decision to come up with several different versions of what actually happened. Starting with, Gannon just ran away. I don't know where he's at. He was supposed to be in a friend's house. To, I got sexually assaulted. Someone took Gannon in a suitcase. That suitcase was another decision she made. Stuffed Gannon in a suitcase after she stuffed him in a suitcase and made the decision, hide the body up in Palmer Lake.
Wrap up.
Then she made a decision to get the body and drive it to Florida, throw it over a bridge.
All right. Mr. Tellini?
Blood slathering all over, wall. Dr. Dorothy. Diagnosed her. Dr. Lewis.
Council approach, please. Juror number 4, we're going to excuse you. All right, I want to read some instructions for you. These are, you'll get some similar instructions at the end of the case if you're selected to serve as a juror in this case, but I think it will inform our discussion going forward. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all of the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. That means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. And the reason for that is she is presumed to be innocent and no evidence has been presented in this case, none. Nothing that the attorneys say ever is evidence. The only evidence in a case comes from a witness who raises their hand, swears to tell the truth, and takes the witness stand. You may also see physical evidence, such as photographs, diagrams, charts, those sorts of things. But you will never see the attorneys in this case take an oath to tell the truth and take the witness stand. They are paid advocates. Their job is to convince you of a particular position, whatever that position is. But that's not any different than any other case. In any civil case, in any divorce case, in any criminal case, the job of the attorneys is to convince you about a particular position that the evidence either does or doesn't show. So this case isn't any different than any of those. So the fact that the attorneys told you what they think that the issues in the case are doesn't change the presumption of innocence here. Ms. Stauch is still presumed innocent, and if I gave you a verdict form right now, the law would require you to fill it out as not guilty. In addition, you may think, or someone may ask you whether or not the defendant has done something wrong, or else she wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in the courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against this defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. You may also find it useful to think of the charges in this case as similar to a recipe from a cookbook. When you actually see the charges, they'll have different elements to them, sort of like ingredients. Now, I want you to think, for instance, if you wanted to make a Denver omelet, and you took some eggs and you scrambled them up, and you added some ham, and you added some cheese, and you added some mushrooms. You might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, that's what they have to prove. They have to prove what they've charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? Everyone wants to hear both sides. But that is not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. The defendant has no obligation to disprove the government's case. Stated differently, the defendant does not have to produce any evidence or any testimony. In fact, defense counsel could take a nap at counsel table, could play cards. I suspect neither one of those are going to happen, but that would not change the prosecution's obligation to prove every element of the charges beyond a reasonable doubt. In addition, every defendant has the constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That is because it is not evidence, does not prove anything, and must not be considered for any purpose. Sometimes the attorneys will ask a question sort of designed to elicit a response from someone such as, well, I know if I were accused of a crime, especially one like this, I would take that stand and I would talk until the cows come home to make sure that everybody knew that I was innocent. As I indicated earlier, that's kind of a trick question because that's not the process that we follow in a court proceeding. In any event, does anybody here know what the number one psychological fear in the population is? It's greater than a fear of death and greater than a fear of meeting up with a rattlesnake on a hiking trail. Anybody know? Public speaking. So naturally, the process is that we bring all of you strangers into a big room with a whole bunch of other strangers and ask you questions and ask you to start talking in front of other people. I want you to think back on that experience. Were you nervous? Were you thinking, gee, did I understand the question right? If you had a choice, would you have chosen not to be questioned? And none of you were questioned in front of a jury by these attorneys regarding facts, and none of you either witnessed or had been accused of a crime in this case. The bottom line is that it is possible that the defendant won't testify. And it's possible that she will. But regardless of who testifies and who doesn't, regardless of whether you want to hear something more from someone or not, the real question you have to decide at the end of the day is always the same. And that is, based on the evidence presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone here who thinks that they cannot give Ms. Stauch the presumption of innocence to which she is entitled? Please raise your hand. All right. Looks like, let me start in the back there. And see, now that we've excused some, I have a harder time figuring out which row you're in exactly. So let's see, juror 38. Yes, ma'am. And how long have you done that? Okay. I think we're going to get to that that's a little bit separate. My question is, and we're going to ask here in just a few minutes, we're going to have, my staff is going to pass out a list, some sheets with some names on it. And the question that I'm going to have is, do you know any of the people, and do you have any witnesses, or do you know any of the witnesses in this case? So wait until we get there. My question is, can you give Letecia Stauch the presumption of innocence to which she's entitled under the law? Okay. And is that based on your contacts with the teacher? Is it based on something else? What's it based on? All right. Anyone else in that row? No. I thought I saw hands in the back row. Okay. Juror 51, yes, ma'am. In the black sweater, yes, ma'am.
Teacher and element. All I know is children are happened to them.
What grades did you teach? Okay. All right. And juror 51, did you have your hand up? Yes, ma'am. Okay. And just for purposes of the record, I think I erroneously referred to her as juror 51. That was actually juror 52 that just spoke. One over here. And juror 29, this is the time to tell us what you had on your mind earlier. Yes. No, it's okay. It's all right. This is a tough case, and it's not a case for everybody. I mean, we have this all the time. I preside also over sex assault on children cases. Nobody is going to say that this is a good thing that happened to anybody. Okay. I think what I'm going to do right now is excuse you. So juror 29, you're excused with a thanks to the court, okay? Anyone else in this front row? Second row? Third row? Fourth row? Yes, sir. Juror 68, yes, sir. Let me see if I can help you with that, because you are not the first juror in this case or any case that has struggled with that, okay? And so let me see if I can help you out a little bit. Every defendant, doesn't matter what the case is, every defendant in a criminal case is presumed to be innocent. The prosecution has to bring evidence to establish the guilt of the defendant beyond a reasonable doubt. With me so far? Okay. So this case isn't any different than any other case in that regard. Ms. Stauch has the right to require the prosecution to prove the elements of the charge against her. And you have to start in with saying, I don't know anything about this case. No evidence has been presented. She's entitled to a presumption of innocence. Can you do that? Okay. And what is it that is holding you up? Okay. Okay. So it is more the personal experience. It's not necessarily it's not necessarily how the evidence shakes out in this case, as it is that you have children that are young and grandchildren that are young. Am I close? Okay. All right. Okay. And you understand that, I'll tell you, I've been doing this for a long time. And I will tell you that I don't think I've ever had an attorney lie to me. But attorneys do have a particular point that they're trying to persuade jurors for. In addition, just like you and I, when we see something, because of our own backgrounds, we sort of see it a little bit differently, even though we could be standing in the same spot, right? So they have their own viewpoints, and they will see evidence. We sometimes have things where the attorneys say, well, this is what this witness is going to say. And then you hear the witness and you go, wait a minute, that's not what I heard. I heard something completely different. And I don't think the attorney was being dishonest. It was just the attorney was thinking, this is how I see it as it fits in and in my role of advocacy and those kinds of things. Does that make sense to you? Okay. So the issue is, can you give Ms. Stauch the presumption of innocence and listen to what comes from the witnesses on the witness stand? I didn't hear that last part of it.
Like what you explained to me, possibly.
Okay. Be hard for you though? Okay. All right. And was there anybody else in that row? Back row. Juror 72. Yes, ma'am.
For me personally, it's just I read the affidavit that was media.
Okay. And we're going to get into that separately. Let me have you hold on to that thought, because we're going to get into the publicity. Because that's a little bit different. So my question is, we'll come back to that when I get to the publicity, okay? Don't let me skip you, all right? Okay. All right. Let's wade right into that now because I think it's probably a good point for it. Have any of you heard anything about this case from any source, including friends, family, the news, other media, or the internet? Just about everybody that's left. Okay. All right. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you, even if you have heard or read something in the media. The real question is whether you can put that aside and decide this case based on the evidence you hear in the courtroom. Is there anyone who thinks they cannot do that? Starting over here, Juror 14? Yes, sir.
I just feel like it's already made up. It's gonna be hard to. Or something like that.
And is there a story or information that you're thinking about particularly?
Not really. I mean, aside from emotional bias, I'm a father to young children, so there's that side of things. But following the story for so long, you kind of create your own narrative of how it went down.
And
It's very hard to convince me otherwise of how I already strongly feel about this case.
and how long have you been following the story?
Since the beginning, my parents live in the same community.
Okay. Did you ever go over to that community while the searches and those things were going on? Okay. Anyone else in this group? No? Over here, anyone? Juror 51? Yes, ma'am.
Long time.
Okay. And, okay. Anyone else in this group over here? And let's, anyone else here aside from juror 72? Juror 72, what's on your mind?
About reading the news. Started reading about.
Okay, all right. So you do not believe that you could give Ms. Stauch the presumption of innocence? 72? Oh, that's what threw me off. Okay. For 45, did you have your hand up, sir?
Yeah.
Yes, sir.
Question about like, what is an opinion or had rationally set that aside, or is it about being like, I couldn't possibly say that I had some creepy.
You know, that's a great question. And here's the best answer that I can give. The prosecution is going to have to prove everything that they're required to prove beyond a reasonable doubt. The defendant is presumed innocent. That's where you have to start from, okay? So the question, and let me start there. Can you give Ms. Stauch the presumption of innocence to which she's entitled? Okay. So then what we look at is the prosecution has to prove everything beyond a reasonable doubt. And as I said, there's certain things that they have to prove. The paragraph number 1 in every criminal case reads the same. In the state of Colorado, on or about the date and place charged. That's essentially what it reads. And then it changes after that, depending on what the crime is that's charged. They have to prove all of that. So you may have in the back of your mind saying, oh, you know, I read about this, or I read, and you'll hear it from the attorneys that there are two different opinions here. You will have, I read in the paper that there was one doctor that said this, and I read in the paper that there was another doctor that may have said this. Okay. So you read that in the paper. Okay. Well, I can tell you that you're probably going to hear from those doctors. Or I suppose it's possible, incredibly unlikely, but possible, that you don't hear from either one of those doctors. And then you have to say, okay, I have some information from the newspaper. There was no witness on the witness stand that said anything about that. Would you be able just to say, I can ignore that and just decide it based on what information I get from the witness stand? Does that answer your question? Okay. It's not that you have to unhear it or unsee it, right? Because we can't do that. So the question is, you have to decide it based on what you hear in the courtroom, not on what somebody else says about something else. Does that make sense? Do you think you can do that?
I guess it's like, so
Right. Right. And what you have to do is just say, okay, that's something that I heard in the paper. I just need to ignore that part. I just need to decide the case based on what somebody has said from the witness stand. Do you think that you can do that? Do you want to think about it for a little bit? Okay, no, that's a fair answer. Okay. Is there anyone else that I've not talked to about that issue that wants to say something? No response. All right. At this point in time, what I'm going to do is I'm going to have Mr. Combs and Mr. Sproul hand out some witness lists. And the question that I'm going to have for you at the end is, do any of you know any of the potential witnesses in this case? I will in a minute. I think we have one that's still working on the witness list. I was waiting until they got done with that first. Right, and are we all done? One juror just left yet? Have you finished with the witness list, sir? Oh, all right. Are there any other witnesses that either side anticipates calling that are not on the, or that may be a witness that are not on the witness list? Prosecution,
Hang on, thanks.
defense?
Possibly Dr. Rhonda Niebenheim, possibly keeping correct.
Does anybody think they know any of the potential witnesses in this case? Mr. Luther? Or I'm sorry, juror 47? Yes, sir. Sorry. Okay. Is there anything about that that you think would cause you any difficulty serving as a juror in this case? Okay. And you said that you retired how long ago? Okay. All right. Anyone else? No? All right. Now that we've narrowed down the group significantly, I want everyone to look around the courtroom. And the question that I have for you is, do any of the potential jurors know each other? All right. Okay. I was worried for a minute because I only saw one hand, but now I see two. So, okay. All right. Juror number 7, who do you know? Okay. And you're referring to juror 14? Okay. If you were selected to serve as a juror and juror 14 were also selected to serve as a juror, would you have any difficulty with that? Would you be able to express your opinions even if they disagreed with those of juror 14? And juror 14, let me ask you the same questions. If you were selected to serve as a juror and juror 7 were also selected to serve as a juror, would you have any difficulty with that? And would you be able to express your opinions even if they disagreed with juror 7's? Okay. Anyone else? No. All right. Okay. Does anyone or do any of the potential jurors know either myself or a member of my staff? response. Is there anything about the nature of this case which would, in and of itself, influence any of you at arriving at a verdict? No response. All right. And I wanted to let you know that if you are selected to serve as a juror in this case, you will only be deciding the facts of this case. In Colorado, now in Colorado, the jurors never decide a sentence. The only time that they did that was when Colorado had the death penalty. This is not a death penalty case. So you only decide the facts of whether or not the prosecution has proven beyond a reasonable doubt everything that it's required to prove. You won't have to decide a sentence if that becomes necessary. Is there anything about hardship or about publicity that anybody wants to tell me that they've not already told me? Juror 38, yes, ma'am. So in the afternoons, okay. Anyone else? Juror 21? Okay. Okay, and that's what I was going to ask. And we understand that people are putting their lives on hold to a certain extent. We also understand that time goes on, and we also understand that things happen in people's lives. So I appreciate you bringing that to our attention. That's one of the reasons why we select more than 12 jurors, because it's possible that something may occur. And if you are selected to serve as a juror, and if something like that happens, we can deal with that. Okay, but I'm glad that you brought it to our attention. Anyone else? All right, no response. We have just a moment. Okay. At this point in time, I'm going to excuse juror 14 here in the front. Juror 38. Juror 51, back row there. Yes, ma'am. And juror 52 right next to her. Juror 68, black shirt. Yes, that's you. Yep. Juror 68 and juror 72. Juror number 41, how are you doing? Yes. Okay. And when you start to have a seizure, do you notice anything before it happens? Okay. Are you still able to communicate when that happens? Okay. And do you have any feelings like that now? Okay. But so far you're doing okay? Okay. Council approach, please. All right, ladies and gentlemen, what we're going to do is take a lunch recess, and I know that it's early. This is our fourth day. Thank you. It's our fourth day in doing this. We're getting a little bit faster every day. Here's what I'll tell you what we're going to do. Over the lunch hour, the attorneys and I will be looking at your questionnaires, so that we have a little bit better feel of some background and some questions to ask and things like that. So we're going to be using our time to look through some questionnaires while you are having lunch. Most of the eating joints are north on Tejon. There are a few south on Tejon as well. There's a bistro that's in the basement. Is it open today? We got an email. I think it's closing early. It's closing early. You should be okay. We're leaving, or you're getting out of here early enough that you should be okay to go to the bistro if you want to do that. Here's what you can do over the lunch hour. You probably will have somebody, a spouse, significant other, somebody who's generally interested in your welfare, wondering what's going on with you. You can tell them that you are in the midst of jury selection. You can tell them it's on this case. You can tell them that if you are selected to serve as a juror, you will come back on April 3, and there will be further questioning of you at that point in time. And you can tell them that if you are selected to serve as a juror, that you will start April 3 and the case will go for approximately 6 weeks. They will ask you more. They may try to give you opinions about things. And here's what you need to do. The judge said, I can't talk to you about it anymore. Those are the only things that I can tell you. You have to decide the issues in this case based only on the evidence that's presented in this courtroom. We've already talked about what evidence is and what evidence is not. So have those people help you, because you're going to have to avoid news exposure. You're going to have to avoid exposure from opinions from friends. And so have those people help you and say, look, I can't talk to you about it. Help me avoid that stuff. If you hear something on the news, change the station. If you read something in the paper, flip the page. Just don't read the story and just flip the page. If someone wants to share their opinion with you, say, I can't do that. The judge said, I can't. That puts the burden on me, not on you. I'm married to a woman who has a lot of really strong opinions, and she's happy to share those with me pretty much whether I want her to or not. And I know that when I go home today, she's going to ask me how my day went. I'll tell her once we get into evidence, she would ask me how those days went, and she would say, well, what did the witnesses have to say? And I'd start to tell her. And at some point, she would look at me and she would say, well, you didn't really believe that, did you? And pretty soon I'm having a conversation about what I should and shouldn't believe with somebody who wasn't even here. You can't do that. If you are selected as a juror in this case, you can't even discuss the case among yourselves while it's going on. You have to wait until the very end. So the way to avoid that is just to say, the judge said, I can't talk to you about it. Because I know if I were to tell my wife, look, I'm just not talking to you about it, it would lead to an entirely different conversation. So this way, it puts the burden on me, not on you. And hopefully you can avoid all of those things that we're trying to avoid. If I can have everyone back in the hallway a little bit before 1 o'clock, we should be able to start on time at that point. Here's what you can expect. When we come back, the prosecution will have 45 minutes to ask you some questions. Then the defense will have 45 minutes to ask you some questions. We'll take another break and we will then strike some other people. Jury selection is actually a process of deselection. As you've noticed, there's not nearly as many of you now as there were when we started the day. So we will start deselecting some of those people. And then at the end of the day, we will have some qualified jurors to come back on April 3. At least that's the hope. So have a good lunch. Enjoy yourselves. Again, you can talk about anything, just not this case. So with that, all rise for the jury, please. Oh, and juror 32, talk to your supervisor, okay? During this time period. Okay. Well, you can just talk to somebody there so that we have some sort of answer, okay? Okay.